Greetings, everyone. Greetings. Just want to see if everyone's here for sure. Cool. Looks like we got some people here today. Today we're going to be exploring constitutional law through American jurisprudence. We went over part 1 and part 2 previously, and we're going to go on part 3 today. Before we were going over the historical context and differences between the American Constitution and previous forms of constitutions. Give me just a moment. We're going to get this up and running here. Okay, looks like we should be ready to go here. Just a moment. Thanks. All right. So we'll also be using Black's Law Dictionary here, 9th edition. And this is going to help us define words as we go along so that we have no word left behind. So this is what we're using here is Black's Law 9th for a reference. And let's get back to where we need to go here. Oops. Okay, there we go. Okay, so previously we had gone over the summary and we went to the distinctions between constitutions and statutes. We went through the characteristics of the constitutions. The functions and the purposes of the Constitution. We did go through the theoretical basis of the American Constitution. We also covered, these are in the previous live streams that are on the playlist. And I'm just getting to where we left off. I don't want to leave anything out here. Yeah, I think this is about where we were leaving off from, if I'm not mistaken. Let me just double check. Yes, so we had the effect of the British constitutional law theory on American constitutional law was where we left off. And one of the biggest differences we came across here was that according to the theory of the English Constitution, absolute despotic power must reside somewhere in all governments. And in Britain, this power is entrusted to Parliament. The power of the British Parliament is so transcendent that it cannot be confined for either causes or persons within any bounds. The principle of the omnipotence of Parliament, however, has not been applied, fortunately, to the legislative bodies in America. Thus, it is recognized that the Congress of the United States as a legislative body is not vested with judicial powers, as is the British Parliament. And I think we're all pretty familiar with the recent use of the right of the United States Senate to try all federal impeachment cases is nonetheless somewhat reminiscent of the judicial power of the English House of Lords. When you think about that, when the Senate is running an impeachment trial, it's really exercising somewhat reminiscent of the judicial power of the English House of Lords. Interesting. We have footnote 10. And in the United States, the Congress and all of its members, as well as the President of the United States, all state and all federal officials, and all state and federal courts and judges are as bound by the United States Constitution as are ordinary citizens. So, again, in jurisprudence, when they say a word like citizens, persons, people, there's always a distinction. So, keep this in mind as we proceed. So, big difference. Another big difference we came upon is that the British Constitution is an unwritten one, whereas the American Constitution, the embodiment of our principles is within that written document. All right, so now let's move along here. And in the comments, if anyone wants to give some comments, we're going to start right now. All right, so what we got going here? The Cherokee claim to have profound influence on the United States Constitution. There's quite a few influences within it, but then you'll find influences within very many constitutions around the world. But there are some distinctions to the American Constitution that, regardless of what influences are in it, it is a design that's has been untested throughout documented history that we have. So that alone makes it something. The very strength of our nation is these principles. All right, so let's continue here. And just test out, we're making sure everything's working good here. I want to, yes. So I forget to do this when I'm answering questions here. I want to be able to pull them up on the screen. And let's proceed here. So we're going over the pre-Constitution national documents. This is the Declaration of Independence, the Northwest Ordinance, and the Articles of Confederation. Now remember, we're going through this in the context of American jurisprudence. So this context here would not apply to most other countries. No, to no other country in the world. And what we're going to find in here is some really nice principles of law that make America very unique in that matter, especially in our judicial system. If you'd like, Justice Berserker, I'm thinking we might have to do a separate panel on just that, because I've accumulated quite a bit of documentation that might say otherwise. But let's continue here. While statements of principles contained in the Declaration of Independence do not have the force of organic law, and therefore cannot be made the basis of any judicial decision as to the limits of rights and duties. Let's break this down before we continue here. While statements of principles, right, they are contained in the Declaration of Independence, they have no force of organic law, and therefore cannot be made the basis of any judicial decision as to the limits of rights and duties. You get that? Declaration of Independence is not going to be cited in a judicial decision as to limits of right and duties. Yet, it is always safe to read the letter of the United States Constitution in the spirit of the Declaration of Independence. Interesting. So when you're interpreting the United States Constitution, it should be done, it's always safe to read it in the spirit of the Declaration of Independence. So that's why it's important to read the Declaration of Independence. The courts have sometimes referred to the Declaration in determining constitutional questions. So there you go. You never know. Any questions you have or clarification, I'm more than happy to pause, because believe me, we're going to be pausing some as soon as we start hitting some of the words that we become unfamiliar with over time here. Okay, so on July 13th, 1787, 2 years before the Constitution of the United States was adopted, Congress enacted the Northwest Ordinance, captioned "An Ordinance for the Government of the Territory of the United States Northwest of the River Ohio." This landmark legislation, which was to have a profoundly important effect on the subsequent development of both state and national law, was the fundamental instrument of government for an area covering more than 250,000 square miles. The territory to which the ordinance applied included all of present-day Michigan, Indiana, Illinois, Wisconsin, and Ohio, and part of Minnesota. The federal courts have generally held that the ordinance was superseded by the adoption of the Constitution of the United States on the ground that the Constitution places all the states of the Union on an equal basis, which would not be the case if the ordinance continued to be in force after the adoption of the organic law, which is the Constitution. Okay, so even after the adoption of the Constitution, however, some of the provisions of the ordinance were continued in force by acts of Congress during the period of territorial government of the Northwest Territory. So, in both the federal courts and those of the states created out of the Northwest Territory, the doctrine that the Northwest Territory had been superseded by the state constitution when a new state has been admitted to the Union is adhered to, and no effect is given to that ordinance, except insofar as its principles may have been embodied in that state constitution. So, following the Revolutionary War, the Articles of Confederation were drafted in 1777 and submitted by the Continental Congress to the state legislators for approval. That's in 1777, right? But they were not approved by all states until 1781. Thus, the states had joined together under the Articles of Confederation. In that system, the states retained most of their sovereignty, like independent nations bound together only by treaties. The newly independent states did not favor a centralized executive authority, and the government ultimately created by the Articles of Confederation amounted to little more than a loose confederation of states that derived its authority from acceptance of the principles of the Confederation by the state legislators through ratification. The Articles created a government with a single branch, a Congress with members appointed by the state legislators. The Articles of Confederation are no longer in effect, of course, having been superseded by the Constitution of the United States in 1789. So we had a nice little period between 1777 and 1781, right, where and then they had joined under the Articles of Confederation. So it wasn't until 1789 that they were able to get all the states under the Constitution of the United States. And then these are all the footnotes for that. I don't see anything specific in here except for just the references. Usually like to stop by and read some of the notes they might have here, but there are none. As we're getting into some of the more historical context here. Oops, let's see. Okay, now we're going on to the purpose, the application, and the effect of United States Constitution. And of course, with American jurisprudence, we have these great the treaties and the practice aids. We have the Constitutional Law Desk Book, Individual Rights, Constitution of the United States of America. Great stuff. All right, let's continue. The several states were in existence as separate sovereignties under the Articles of Confederation prior to the adoption of the Constitution of the United States. The Constitution brought into being a nation and a closer union rather than a league of separate states. The Constitution was framed upon the theory that the peoples of several states must sink or swim together, and that in the long run, prosperity and salvation are in union and not division. You got that? Prosperity and salvation are in union, not division. And that's, of course, in the long run. So that's some pretty cool ways to look at this. And we look at it into that context of the challenges of the Constitution at that time. when you had competing documents like the Articles of Confederation, and you're leaving a country like Britain where they had no written constitution per se. So this was all new territory for both the land and the experiment in government. Let's continue. Although providing for the common defense is one of the purposes of the federal Constitution, the Constitution was also intended to protect the people. Notice how we have the people, not citizens, the people of the United States against arbitrary action by their own government. Let's read this again here. This is very important. Although providing for the common defense is one of the purposes of the federal Constitution, the Constitution was also intended to protect the people of the United States against arbitrary action by their own government. It was designed for the common and equal benefit of all the people of the United States, as well as to create a national economic union. I'm just going to take a brief break here and look at what we have in the comments here. Archangel for Truth, I'll read this out. It says, Declaration of Independence was inserted into the U.S. codes as its beginning because the DOI was ratified and readopted by both the House and the Senate. Yeah, so the Declaration of Independence was parts of it or basically were incorporated through the various acts, but the principles, the spirit of it still exists as a lens to view the Constitution. Let's continue here. The principal features of the American system of government established by the United States Constitution include representative government, dual government involving both state and federal aspects, the securing of individual rights and privileges through constitutional restrictions. So let's look at this here a little bit too. Let's start to enumerate this here. We have the principal features of the American system of government. The principal features of the American system of government established by the United States Constitution include representative government, that's one of the things, dual government involving both state and federal aspects, and notice the footnotes, so we'll look at these and see if there's any further notes. The securing of individual rights and privileges through constitutional restrictions. So nothing is being given, it's being secured. And a separation of powers among the legislative, executive, and judicial branches of either government, as well as between the governments themselves. We're talking the state and federal. The Constitution of the United States was ordained and established, not by the states in their sovereign capacities, but, as the preamble to the Constitution declares, by the people of the United States. And was adopted by their voluntary act for their own protection. It was particularly intended to affect individuals rather than states. Interesting, huh? So the preamble declares it was adopted by the people of the United States and adopted as their voluntary act for their own protection. If you're not being protected, then why would you adopt it? It was particularly intended to affect individuals rather than states. So the Constitution was particularly intended to influence or affect individuals rather than the states. Yeah, so the enumerated rights are going to have to be protected too, because again, some of these things were almost seemed to be afterthoughts, or perhaps some were trying to leave out in the initial composition of the Constitution. So we have a lot of amendments that cover some of this. The provisions of the United States Constitution must be given full force and effect throughout the Union because it is the supreme law of the land. So the provisions must be given full force, not may or should, must be given full force and effect throughout the Union. Thus, the federal Constitution is in reality a part of the Constitution of every state and may be so regarded in determining the validity of legislative acts. It operates alike on all states and the District of Columbia, and by statute, Congress has also extended specific provisions of the United States Constitution to Guam, the Virgin Islands, and Puerto Rico. So, here we go. Great observation in American jurisprudence. These observations really help sum up all the details we just read. The Commonwealth of Puerto Rico continues to be a political subdivision of the United States, and federal statutes using the term territory may still be applicable to it. And when you start to break things like the Commonwealth of Puerto Rico, and then you start to also look at Indian tribes, you start to find certain things where statutes start to come into conflict with other terms that we might be operating by. So let's look at the footnotes here, see if there's any notes on them. No. So this is another good one too, states, territories, and dependencies in American jurisprudence. And this is the one for Deborah that we could go over, but I don't have this one. I think Audit Them does, so perhaps he could do that review. Okay, now we're getting to the purpose, the application, and effect of state constitutions. So now this is going to be state constitutions. Under the American system, each state was left free to establish a constitution for itself, and in that constitution to provide such limitations and restrictions on the powers of its particular government as its judgment might dictate. A state constitution and the statutes of the state are to be taken together as making one body of law. So this is some pretty interesting stuff here. A state constitution and the statutes of the state are to be taken together as making one body of law. However, an expression of the will of the people as an expression of the will of the people. Of course, here we're back to the will of the people. A state constitution stands above legislative or judge-made law, inasmuch as the state's constitution is the supreme, paramount law of the state, and is second in that state only to the United States Constitution in importance and precedence. So the Constitution of the United States is always going to be more important and have precedence over a state constitution. So again, it's an expression. Even state constitutions are an expression of the will of the people, not citizens, persons, public. It says the people. So let's continue here. Adoption of the United States Constitution. So the adoption, let's see what's going on in the chat here before we move. Let's see what we got here. Since they work for the state, not sure who you're referring to as far as working for the state, but yeah, if you're talking about the if you're talking about people that work for the state, they still, even though if they're following all the rules and the policies, laws, constitution of their state, if they're violating any part of the United States Constitution, then there would still be a conflict there in law that would be addressed to the courts properly. All right, so where do we leave here? Sorry, I went down here. So the adoption of the Constitution of the United States is traceable to the people's disappointment with the Confederation of States, which they had formed in the warmth of mutual confidence after the Revolutionary War. Amazing, huh? So the adoption of the Constitution is traceable to the people's disappointment. Wow. With the Confederation of States, which they had formed in the, I love this, the warmth of mutual confidence after the Revolutionary War. Experience had made it clear that a national government was required for national purposes. Because of this, they determined to establish a federal or national union of states for the purposes set forth in the preamble to the Constitution, which recites, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Do ordain and establish this Constitution for the United States of America." The Federal Convention met in 1787 to write the present Constitution of the United States. Several drafts of it were presented for consideration of the Convention. In September 1787, the Convention completed the great work in which it had been engaged and resolved that the Constitution should be laid before the Congress of the United States to be submitted by that body to the conventions of the several states to be convened by their respective legislatures. The Convention expressed the opinion that as soon as the Constitution should be ratified by the conventions of 9 states, Congress should fix a day on which electors should be appointed by the states, a day on which the electors should assemble to vote for president and vice president, and the time and place for commencing proceedings under this Constitution. When the conventions of more than 9 states adopted the Constitution, Congress on September 13, 1788, passed a resolution in conformity with the opinions expressed by the Constitutional Convention and appointed the first Wednesday in March of the ensuing year as the day, and then set the seat of Congress as the place for commencing proceedings under the Constitution. The Constitution went into effect in March of 1789. And let's see what we got going here. Yeah, you have rights. When they do that kind of stuff, yeah, this is terrible when you see these abuses. But again, the disappointment with these abuses is what brought about such a powerful document like the Constitution to protect the people from this kind of very tyranny you're talking about here. And yeah, there's been a lot of crazy things that have gone on that are considered unconstitutional. But when you can express it effectively with these types of arguments that are in American jurisprudence, it's going to be hard to rebut. As you can see, we're going to look at what we're getting as a foundation here. And by having this foundation, at least having gone out over it, even in this context, means that when you apply some of these principles of law to maybe your own situations, you're going to have a deeper understanding, not just of how to do it and how others have done it before in the case holdings and such to support your interpretations. But just to have the spirit of the law down right, so that you're doing it for the intent it was made, and you're really showing how the people that are perverting the intent are what's wrong and not the laws itself. I think we're done with this section, right? Yes. Well, here we are. The original version of the United States Constitution, sent to the states for ratification in 1787, did not contain a Bill of Rights and did not otherwise address the issue of religious freedom. Now we get the public demand, not the people's demand, but the public demand. The public demand for protection of their rights was reflected in the various states ratifying conventions. Most of these conventions called for the inclusion of a Bill of Rights in the United States Constitution and patterned their recommendations after their own constitutions and declarations of rights. Let's see how that ended up. Then we had the adoption of state constitutions. So the various states in the United States have from time to time adopted state constitutions, which declare and guarantee the rights and liberties of the individual. Governmental authority in each state is vested by the state constitutions in the three great divisions of government: the executive, legislative, and judicial authorities. The agencies or departments so created are the agents of the people. They are, in general, separate and distinct departments or agencies, independent of each other, except to the extent that the action of one is made to constitute a restraint upon the others, to keep them within proper bounds, and prevent hasty and improvident actions. So we haven't been looking at Black's Law, but let's look improvident, if it's in Black's Law, just to see if perhaps it is a word that we should be looking up. Oh, great. Hang on a second. This is the first word's always the worst to look up here. All right, give me a second here. Oh, Lord. Okay. Black's Law. Where'd it go? Well, we're just going to zoom through it then. I was going to look for the search here, but we can't. And the thing about this is that it's hard to see the headings up here. But we ended up on one of my favorite pages here of liens. I'm just waiting for this thing to catch up here. Let me read some of the comments here. I've got some long ones here, not quite fitting on the screen. I'm going to try and get it read the rest of it. Lowering the water amount of gallons we get and raising the price of what we have to pay, the fees. People always think I was processing them. So how can they lower the water amount? I mean, that doesn't make sense, does it? That's really strange. And the old people want to protest over there. Yeah, that's pretty strange. Archangel is saying here that the Bill of Rights refer to the unenumerated rights of the ninth as retained rights, right? The word retains means we keep these unless the enumerated rights despite the enumeration of the Constitution, right? But then that gets into a very convoluted argument or interpretation that we'll get into later. But right now I want to get the foundations of what we're talking about here, just so we can Pardon me. You gotta bear with me just one moment here. I'm looking up here. Okay, government authorities, Great Division, improvident. There it is. Problem is, this is a scanned document here, just for me to go online with, so it is very difficult to sometimes search, and it's slow. So just have to bear with us for the first one through here, and if I can locate, you know what? Hang on a second. I think I might know where I can search it quicker than this. Yeah, give me one moment here, and feel free to put some comments. I'll answer them in just a second too. Here we go. Excellent. And that's page 54. All right. Here it is. Improvident. 16th century. Lacking foresight and care in the management of property. Of or relating to a judgment arrived at by using misleading information or a mistaken assumption. So this is an interesting term here, isn't it? Improvident. Lacking foresight and care in the management of property. So it's not about people, it's about property. But then it's of or relating to a judgment arrived at by using misleading information or a mistaken assumption. Share your screen how? You have someone teach me how to share my screen. I could give you a link if you want to share your screen. I could bring you in here too. What do you want to show on the screen? That's all right. I'm kind of like learning this stuff as I go along. So what you're seeing here is I've put this together myself. This isn't any kind of, there's not one software or anything I'm using here. So let's continue here. If you want to share your screen, I meant so I can do videos too. Oh, if you want to stream to YouTube or something like that, then that's easy to do. If you just want to do that. If you'd like to share with this stream, I can give you a link and you can come up and do that too. Yeah, how'd you know I was using OBS? Yep. OBS I like because it's open source, and I like the stuff that's open source because not only is it free, but you don't have all the intermediaries in there, and for the most part, it's stuff that oh shoot, let me get this here, make my sound a little bit better. Is that better there? The open source is really it's got a community of developers in it, so there's a lot of eyes on all the security issues and functionalities, and they add things in there that would you normally not even think about adding, just because there's a lot of developers that got nothing better to do with their time than to make great software. That's how they like to spend their time. So this word here, improvident, is really good because if someone gets to a judgment, they arrive at a judgment by using misleading or mistaken assumptions, misleading information or mistaken assumptions. That's improvidence. A lack of foresight and care in the management of property, especially as grounds for removing an estate administrator. Interesting, an estate administrator. And that goes to the 15th century, so improvident, 16th century in law. One thing you'll notice about the 9th edition of Black's, we don't have the case laws all the time at the end of this, whereas in the first and second and earlier editions they do. Oh, yeah. So let's see here. I'm going to go back to AmJur here. So now we know the agencies or departments so created are the agents of the people. These are, let's get back here, governmental authority in each state vested by the state constitutions and in the three great divisions of government. So it's the same, executive, legislative, and judicial. The agencies or departments so created are the agents of the people. So everything in a state constitution, all the agencies and departments are so created to be agents of the people. They are, in general, separate and distinct departments or agencies independent of each other, except to the extent that the action of one is made to constitute a restraint upon the others, to keep them within the proper bounds and prevent hasty, overly fast and improvident, which we just looked up, and that means that there's false information actions, judgments arriving from false information. Some state constitutions contain a mandatory provision for a periodic opportunity for revision by convention. So we've heard of constitutional conventions, mandatory provision for a periodic opportunity, but again, that's not required to do, just to have an opportunity prescribed to do it. No, you want to get in the live stream? There's videos. YouTube will let you in the live stream. If anyone wants to come in, just let me know towards the end here, and I'll provide a link because it's going to take a little bit of time to get you up here. But I can, and if you want to present, you can also share. If you have any documents or videos or anything you need to share with the audience, we can. All right, let's continue here. Amendment of the United States Constitution generally, so the amendment process. Article 5 of the United States Constitution governs amendments to the Constitution. The adoption of this article reflects both the framers' realization that the Constitution might, in the progress of time and in the development of new conditions, require changes, and their intention to provide an orderly manner in which these changes could be accomplished. This article alone confers the power to amend and determines the manner in which the power can be exercised, the power to amend it. Insofar as it speaks on that subject, Article 5 is supreme, and any provision of a state constitution in conflict therewith must be held at naught. Article 5 ensures that deliberation and consideration must precede any proposed change in the Constitution. Deliberation and consideration before any proposed change. See how the process is very orderly and complex for a reason. The Constitution provides two methods of proposing amendments: by the Congress and by convention. Article 5 further specifies that amendments are valid to all intents and purposes when ratified by the legislators of 3/4 of the states, or by conventions in 3/4 of the states. Oh yeah, that's some pretty heavy stuff there. Now the conventions, good luck getting 3/4 of the states here to agree on anything. Any question as to whether the amendment procedure was properly followed is a federal question, which necessarily must ultimately be decided by the United States Supreme Court. And state and federal courts are bound by the decisions of the Supreme Court as to the validity of amendments to the Constitution. So the Supreme Court holds these amendments in hostage, and the Supreme Court is appointed. That's footnote 8, 1931. Okay. I just realized I have a comment here. All right. So we're on the proposal of amendments to the United States Constitution. Amendments to the United States Constitution are proposed by Congress whenever 2/3 of both houses deem it necessary or by a constitutional convention. In proposing an amendment to the Constitution, Congress is not acting strictly in the exercise of ordinary legislative power, and a congressional resolution proposing an amendment does not require the approval of the President, nor is it affected by a presidential veto. Interesting. The United States Constitution contains no limit to what Congress can propose in the way of an amendment to the Constitution, except that no state can be stripped of its equal suffrage in the Senate without its consent. The Supreme Court has thus remarked that an examination of Article 5 discloses that it is intended to invest Congress with a wide range of power in proposing amendments. Various amendments have been attacked before the Supreme Court as beyond the power of Congress to propose, but such attacks have always failed. Wow. In proposing an amendment, Congress needs not include an express declaration that the House is both regarded as essential, since the joint resolution is sufficient to show that the proposed amendment was deemed necessary. So in proposing the amendment, it does not need to include an express declaration that the Houses both agree it's essential, since they already have a joint resolution. That's sufficient to show. Oops, I see here. Yeah. Well, this is true right here, Justice Berserker. So Article 5 also provides that Congress, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments. So on the application of the legislators of 2/3 of several states, shall call a convention for proposing amendments. So the Supreme Court has interpreted shall to mean must, yes. So that the words of this article are preemptory. And nothing, so it preempts it, right? Or no, wait, peremptory. Wait, we got a new word. Oh, geez. Peremptory. Okay. No, so peremptory. Here we go. 12. Yeah, we're low tech here. It's all manual for me. Okay, I'm on the wrong one here. I got a second. Come on. You gotta be kidding. Wow, it's really giving me a hard time to move to it. Some other guys didn't like it. Oh, I see what's wrong. We didn't go to Black's Law. There we go. I'm not seeing everything you guys see. I got a bunch of hodgepodge patchwork going here to make this work tonight. So I appreciate the patience with you guys for me too. Oh, wait a second. We're not on the right page, are we? We're on defenses. Oh, geez. Yeah, we're on the D's. Hang on. We're looking at the peremptory defense. That's not the word. We want peremptory as itself. All right, here we go. There we go. Peremption, peremptory. Wow, it's an old word. So, peremptory is an adjective, 15th century, final, absolute, conclusive, incontrovertible. A king's peremptory order, not requiring any shown cause, arbitrary, peremptory, final, absolute, conclusive. So peremption is from civil law, a period of time fixed by statute for the existence of a right. Wow. If the right is not exercised during this period, it is extinguished. Whereas prescription simply bars a specific remedy, peremption bars the action itself. Wow. Limitation of actions. So peremptory challenge, peremptory defense. They have a lot of these. I was looking to get here. So let's continue. All right, so we get the peremptory down. All right, so that the words of this article are peremptory, final, and nothing in this particular is left to the discretion of Congress. However, Congress must, of necessity, decide whether the conditions exist which give rise to this duty, and it must decide whether the applications for a constitutional convention are valid and when a sufficient number of states have petitioned for a convention. So, who's deciding on this? Supreme Court has interpreted this to mean shall. Congress must, of necessity, decide whether the conditions exist which give rise to the duty, and it must decide whether the applications for a constitutional convention are valid when a sufficient number of states have petitioned for a convention. All right? A resolution by a state legislator calling for a national constitutional convention to consider a particular amendment to the Constitution is held to constitute a sufficient application to Congress within the requirement of Article 5, without the signature of the governor of the state. So just a resolution of the state legislator calling for a national constitutional convention to consider a particular amendment of the Constitution is held to constitute a sufficient application to Congress within the Article 5 requirements without getting the governor to sign. Yep, so let's continue here. So this was involving the 19th Amendment extending suffrage to women as 1922. So again, now the thing about American jurisprudence is now we're using a 2022 version of this, so we're very up to date. But when you come in understanding the law behind any particular case from this standpoint of common law and American jurisprudence, it takes into consideration every other aspect, but it starts from that strong foundation of the American jurisprudence and the American style of common law. And with that, I believe it gives you an immense advantage anytime you're in an adversarial position in a court of law in the United States of America. All right, let's continue here. Conclusion of a mandatory process to the United States Constitution, notice and proclamation. Whenever official notice is received at the National Archives and Records Administration that any amendment proposed to the Constitution of the United States has been adopted, according to the provisions of the Constitution, the archivist of the United States must forthwith cause the amendment to be published, with the archivist's certificate specifying the states by which the same may have been adopted, in that the same has become valid, to all intents and purposes, as a part of the Constitution of the United States. So we're getting into those amendments here. The principle that if a legislative document is authenticated in regular form by the appropriate officials, a court will treat the document as properly adopted is equally applicable to constitutional amendments. So I was noticing some stuff here. Interesting point you make here. You have rights. I'm glad I cut off the last part, the offensive part there, but we get the gist of it here. You can't be prosecuted by a court that's not a court of law. It'd be an unlawful prosecution, wouldn't it? I think it's the way you're perceiving this, in that if the court's not moving honorably, then it's up to you to enforce your rights in that court. If they're not going to afford you a judicial process, you have to demand it. And if they deprive you of the judicial process, then that's a case for a federal court. I don't see any way that you can get away with depriving people of their rights just because you call it a different kind of court. I mean, these judges, they do administrative law in one docket, and they go right to a docket of civil or criminal. They could, whatever it might be. But when they're in that court, they follow the rules of procedure of the court they're in, whether it's civil procedure, criminal procedure, administrative law. They have to follow the laws or the rules of their courts when they're doing those cases. And if they're talking about a case, cause for appeal, yeah, in a way, perhaps. But the important thing is what's on that record. The most important thing is getting on your record is to make sure that what goes into the appellate court is on record. Because if it's not on record, it's as if it didn't really happen. And appellate courts are notoriously difficult to deal with when it comes to certain aspects like this. Because it's not really for this conversation here, but the important thing is to know your rights, to know the precedence and the supremacy of the Constitution first, so that when you hear all this funny sounding stuff going on, you're able to call it out for what it is, not just to complain and scream that you're violating my rights, but when you can express it effectively in writing and articulate it based on these historical contexts and people with holdings of judgment that are far wiser than us, you can draw on that as to support your interpretation of how you were treated. And when you come from that approach, it's really hard in an honorable court to be able to challenge it and prevail over you if they're only working on dishonesty and malfeasance. But that's just how I feel. You're right about that. You have rights. There's no doubt that's correct. But you still have to know that. Just because they do that doesn't make it right. And just because they do that doesn't mean you don't have to stop them either. Let's continue. Thus, a duly authenticated official notice to the archivist that a state legislature or state convention having authority to adopt a resolution ratifying a proposed amendment has done so conclusively upon the archivist and when certified by their proclamation. Okay, so this is the kind of stuff we're probably not going to be seeing in our lifetime. We'll just continue on past amending the Constitution here and get to the good stuff. So ratification of amendments. So this is the technical parts of the government's role in keeping our Constitution by referendum. And this is going to be a little bit too much for, I think, what we want to go over today. So I'm going to just pass this. Time for ratification. We have rescission or retraction of ratified United States Constitution. Again, these are very special issues here. If there's anyone that has a particular issue where this would apply, let me know and we'll stop and dig into here, but I'm not aware of anyone challenging any of this right now. So, amendment of state constitutions. This happens a lot more frequently, of course, but very rarely still. And then we get down to the subject matter and permissible scope of amendments to state constitutions. Let's see here. Preamble may be amended, including provisions authorizing the making of amendments. So yeah, this is again, in the lawmaking process is probably beyond the scope of what we want to discuss here as far as American jurisprudence. But if you were in that role, as you can see, the same body of work would apply, just as it would for us even in a civil case or administrative case or criminal case. Subject matter and permissible scope of amendments to state constitutions, federal limitations. So there's federal limitations on the amendments a state can make to their constitution. Methods of amendments. Amendment of state constitutions by petition. Amendment by state constitutions by initiatives. Lots of ways to do things that never get done. Effectuation of amendment of state constitution by submission to vote of the people. And then we get to the amendment of state constitutions by constitutional conventions. I think that should be getting towards the end of it there. The qualifications for elections to your and the powers of constitutional convention. So as you can see here, the amendments, they go on and on about the lawmaking process, because that is a major part of the Constitution, is establishing our government as well as protecting our rights. Link to my resources. Just come to my channel. These are documents you could get from any law library. This is American Jurisprudence. This is a huge body of work. It really has a lot of just so much in it. And what I'm really trying to do with these live streams, and they are very long, and they might seem to be a bit dry in some ways, but what I'm really trying to do is to let people understand the process of using this information. As you're seeing, it's not written for a rocket scientist or anything like that, or for a rocket surgeon. This is written for common people to understand. And it gets into the extreme details that even the most advanced law practitioner would have to refer to. This is it right here, where you do your case law research. But you have to come up with your arguments and support it. Hopefully these will have good arguments in here that would support your interpretation of how the law applies in your case. But understanding these fundamental principles behind our style of jurisprudence in America gives you an approach to going through this information that seems to be overwhelming to many. And I'd really like to make sure that people understand it's not a straightforward cookbook approach. As you see, we try to keep everything handy as you would if you were doing law research yourself. You have your Black's Law Dictionary handy there. You probably have Bovier's. You'll have American Jurisprudence, a few other references, Corpus Secundum. The Reese's Candy, yeah. I get a lot of resources, and I really like sharing them with everybody, because it is it's a way of expanding this knowledge. I don't know how many people are here right now. If we have 8 people that are out there that actually practice what they're learning here today in just one time, it would make a difference for everyone. All it takes is 10 people to go in court speaking like this of the common people. What I've found is most of those esquires in courts are just buddies with the fudge, and they just go out and they play golf or watch the game together or do what they have, and they're always very congenial with each other. And when you consider that you're supposed to be in an adversarial position, and it brings questions to mind. Let's see what we got going here. Yeah, the appellate court will likely not address issues not raised in the initial proceeding. They won't. And you have to basically get here's a good approach, I'd say, is when you're in front of that judge in your initial case, and if they're not behaving well, you don't have a problem with that judge directly now. You're not going to fight it out with that judge in that venue. What you want to do is get as much of his, improper actions, malfeasance onto the record and clearly. When you make an objection, he overrules it unlawfully, you renew your objection. I think the best thing you want to do. Oh well, if you're going into Zoom court, good luck. Last time, no, I don't. I would not consent to Zoom court. I mean, unless it's just very, very inconvenient. Uh, Nonetheless, the basic thing is that you want to make sure that everything gets on the record clearly, because I don't look at like I'm fighting that judge in front of me. I imagine there's this appellate judge looking over his shoulder, and that judge in front of you doesn't even know the appellate judge is watching over his shoulder the whole time. The problem is that appellate judge doesn't see anything going on in the proceedings except what's entering into the record. So if you're not getting the unlawful overruling of objections or unlawful due process into the record in a way that it can be addressed effectively through the appellate court when you make your pleadings, then it's not worth it, because the appellate courts really don't want to do this in most cases, is what I've noticed. So you're 2 hours away. Let's see here. And there's another thing is the Attorney General is besties with the jurist who's, yeah, so we got a lot of things in the Cherokee tribal courts. I would think that's a place to challenge jurisdiction and other ways too, but I don't see that you get a 100-page appeal. Well, appeals are always huge. I mean, even when you file your appeal, when you file what, a brief? And the brief is going to be like 50 pages long. Not very brief, in my opinion. So there's all these aspects where you'd want to check out these, the different situations you find yourself in. The best thing you can do is to prepare your pleadings properly. If you're the plaintiff, if you're on the defense, you want to prepare affirmative defense. So at least you can make some allegations back as you're defending yourself, and it'll help protect you a lot more. Yeah, Justice Berserker, I don't want to talk about your case here, but I feel that, that there's a strange way they approach jurisdiction in your whole case. But I don't know enough about it to really make any opinion other than just what I feel. On that note, let me just get back to this really quick here and see if we can find a convenient place to leave off so we can continue next time with the meat of the matter, so to speak. Because what we're getting in here is a little bit of the government lawmaking process that I wanted to get over and get back to the parts of our rights. The initial part with the summaries and such were really powerful. The part one of this is probably my favorite that I did. There's a stream with part one of constitutional law, and that it's emotionally impactful, I believe, because of the way it's written. And I'm talking about in the prose of the American jurisprudence, let alone the quotes they put in there. So if you really want to feel, more love and loyalty for your country, you read some of that and you'll know what's worth fighting for here. Not the politicians, that's for sure. And let me get down here and see. I saw some interesting one here. Casino. Oh, geez. Advisory 2014 in Florida, Attorney General, use of marijuana for certain medical conditions. Florida Greyhound Association versus state. So we got some interesting footnotes here with amendments. Oh, gambling amendments. Cannabis. Yeah, I get it. All right. So yeah, that's where this stuff comes in importance. So if anyone's working on those kinds of things of changing amendments and laws like that, then let's see, we have simultaneous, successive, or conflicting principles in regard to the amendment. We need to get past these amendments is what we need to do. Here we go. One person, one vote principle in regard to the amendment of states. Number and vote count of votes. Well, this looks like a good one. In fact, I think we could probably leave off here, and this would be a good one to start next time because it is election day, isn't it? So this would be a serendipitous place to take off for our next one. And that way we can see if they're doing a good job counting all those votes that are being cast. And that's page 102 of constitutional law. Great. And section 38. I'm just writing this down so I know, because the way this digital stuff is, you can't use bookmarks like the hardcover ones. All right. So let me see if I have any other unanswered questions on the panel here. I get a great court case, but can't share the link. What kind of court case is it? Is it your personal court case, or is it just one we can refer to? Well, the change in truth is going to come from us. We need to demand it. Indeed. Well, thank you, Justice Berserker. I appreciate that. And I think that's we're pretty good here. I think we've covered. Is there any other questions that we have? I'd love to continue on this with more of the constitutional law. And if you subscribe to the channel and watch for notifications, you want to share a video? Yeah. So what I could do is, we're still online, right? All right. So that had a little glitch there in the stream. Yeah, you want to share a video? I need to prepare a link. So what I could do is I could say this is the end of the stream here, as far as the constitutional law part 3, and we'll continue next time with the voting section. And what I could do now, if you just bear with me for a moment, I'm going to set up some little web stuff and do a little bit of quick coding. I got a hard code in here real quick to make this work, but I'm going to give you a link in a few. Just give me a minute. I'll throw on a little bit of music or something and keep it going. Again, I just want to thank everybody for coming today and spending time to take this journey with me. As I always say, I'm not a law expert or not giving law or legal advice in any way, shape, or form. This is all just an exploration of American jurisprudence and the foundations of our American style of common law that's not being taught enough, that's not being practiced enough, and not being demanded enough by the people. And this, in my opinion, is the best way to get a restoration of probably the best form of judicial remedies we can find in the world today, whether you like it or not. And it's up to us to guard it and protect it and to use it. So on that note, I'd like to thank everybody for coming today, and please stay subscribed and watch for the notifications. I believe they should be going out pretty well, so everyone should get them. And I'll keep these in a playlist too, so that we can all refer back to them and share them with others that might find them useful. I know it's a bit long form. I try to highlight the words I'm reading so that if you do have to fast forward through them at a later time, at least you'll know what we're talking about by looking at the screen and help you access different parts quicker. So on that note, I want to thank you very much. Citizens Broadcasting, if you want to just stay on, and I'm going to keep the stream on anyways, but I got to work in the background here and get this set up for a link. And then either you guys could check back in to see if I got the link up, or if we decide I could just restart a stream and send out another notification. But either way, let me get this going here. So Citizens Broadcast just, let me see, where is it? Yeah, it's a 1 minute video. Okay. It's going to take me more than 1 minute to get it set up, but it'll be worth it. And I think it's nice to be able to share like this. So, you have a folk song written about it? That's great. 15th century history of Ireland.